Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I am going to talk about the can I reimburse costs of sponsoring me on a work permit under the skilled worker visa. So I have seen many times employers, even students who are moving on to skilled worker visas, etc., they do query us. So I wanted to make this video whether the costs can be shared between the employer and the employee. So mainly these are the costs. We do sponsor licensing, we do everything under this umbrella quite frequently. So I remember many of the costs. I've just noted down here. Firstly, the employer, if they don't have a sponsor license, they will need to apply for a license. And usually if it is a small employer, it is 536. That is the cost that they pay. And ISC, if they're a small employer, it is 364 per year. 364, I think that is around, don't quote me on this, but it is around 364 per year of visa that the employer will pay, and the cost fees. If they apply for the costs, 199 is the cost fees, whether defined costs or undefined costs. So these are mainly the costs that the employer will bear before they give you the certificate of sponsorship. So this is when they apply for the sponsor license. Usually it is expected that at least the sponsor licensing cost, all these costs can be borne by the employee. There is nothing wrong with that. Usually only the ISC, which is the immigration skills charge, which will be paid along with the cost fees of 199. Even the cost fees the employee can bear. So all the costs can be transferred to you as an employee. So if you have found an employer, so let's say, for example, let me just take, you are on a student visa in the UK, or you are on a graduate route, and you have found an employer does not have a sponsor license, and you have agreed with the employer that you can bear the costs of the sponsoring, etc. You can bear all the costs, maybe except the immigration skills charge, which the employer should pay ideally. Home office will definitely not like. The ISC will be being paid by the employee as well. So that is one. Maybe other costs can be transferred to you. You can bear them. They can be reimbursed either in advance, later through salaries, etc. 199 of the cost fees can be reimbursed from the employee. 536 sponsor license. Ideally, my position would be that so employer should bear the 536, but there is no hard and fast rule on that. 536 as such, because it's an employer sponsor license and it's valid for 4 years, the employer can sponsor other migrants as well. So technically, from whatever experience I have seen, any queries coming from home office, etc., the 536 and the ISC should be borne by the employer. Everything else can be transferred to the employee. Even the sponsor license can be transferred. It's very case specific. We have to see how the situation is. So the immigration health surcharge can be paid by the employee or reimbursed by the employee, paid by the employer, doesn't matter however you arrange it. Visa application fees can be borne by the employee. Super priority fees, any dependents, if you have any family members, all their fees can be borne by the employee. So yes, if you are an employee and if you are a migrant and you are on a student visa or a graduate route visa or any other visa, you are speaking to your employer, yes, you can go with this plan that you can reimburse them the costs. Also, yes, if you are the employer, then yes, you can reimburse this cost from them. For your specific situation, do definitely book a consultation with us. And if you do like this video, do give us a thumbs up. Follow us on various social platforms. Do subscribe to our channel, definitely. Please do subscribe to our channel. It means a lot and it helps us, it motivates us to make more and more videos on different UK immigration law aspects. And thank you very much.